Hey everyone, welcome to another edition of the Daily Bullet. Well, the Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today, as he does every other Friday for Legal Friday, Alex Ooley. Alex, of course, is an attorney in Southern Indiana and the man behind the Forge of Freedom podcast. Alex, thanks for coming along today, man.
Yeah, great to be with you, Paul. Thanks for having me.
Getting social media hooked up here. And as I do that, I want to remind everybody, if you would like to comment on anything you hear today, or if you have any legal comments you'd like to make, just go ahead and comment on the live Facebook or YouTube videos if they're on the Polite Society podcast pages. If you're commenting anywhere else, we may or may not see them. And if I do see them and they're relevant, I'll get them up. But I want to explain also real quick. We are starting a couple hours late tonight, and I apologize for that. Had some family issues I was hoping to take care of that got delayed until tomorrow. But Alex was gracious enough to start a little bit late for me. So.
I'm still on Central Time. I was in Texas all week, so I still feel like I'm on Central Time.
All right. First case I want to talk about, Alex. This one hit yesterday. So, it was late yesterday, but the Supreme Court decided to decide gun rights take case on domestic violence. This is off rollcall.com. Supreme Court will decide whether federal law can prohibit gun possession for people who are subject to domestic violence orders. The first Second Amendment case at the High Court since a decision last year that expanded the right to carry firearms in public. So this happened today. Friday's announcement from the justices comes after a wave of decisions on gun laws from appeals courts in the wake of the Supreme Court ruling in New York State Rifle and Pistol versus Bruin. And then just you're going to skip down to the justices will likely hear the next term starting in October and issue a decision before the end of June. So I'm almost as pumped about this as I was Bruin, because I didn't think Bruin was going to be as good as Bruin was. This one excites me. The people who have domestic violence restraining orders have not been convicted of a single thing in most instances. Mainly what's happening is one person goes to a judge and says, this person threatened me, and the judge, being honestly conservative, saying, well, if I don't do something and something happens to this person, it's going to look bad on me, usually just issues the initial order, and then somebody's gun rights go away at least until it's cleared up.
Yeah, that's exactly right. In this case, involves, as you mentioned, a civil restraining order, so there's no criminal conviction associated with the restraining order that's being challenged here. So the problem with these civil restraining orders is that they're often issued just as a matter of routine or course in the matter of proceedings in domestic relations cases, or without any case at all, just as simply a request for a restraining order. And so they're often issued without a hearing, without any due process, and you're deprived of your right to carry a firearm under federal statute, 18 U.S.C. 922 G8. And the Fifth Circuit here said that that prohibition under federal statute is unconstitutional, and the Supreme Court announced today that they are going to grant cert. They're going to grant review of that case. So expect the Supreme Court to review this case sometime in the fall and issue a decision 9 months to a year from now on this particular issue. The one, there's a few interesting things about this case. The bad thing, I suppose, is that the plaintiff, Rahimi, is not exactly a model plaintiff like Dick Heller. Dick Heller, you couldn't have asked for a better plaintiff in Heller versus D.C., but Rahimi has quite a checkered past, to put it lightly.
That's a good way to put it.
Yeah, exactly. And it's concerning for that reason, but I'm optimistic, like you, Paul, that the Supreme Court will issue a strong opinion, hopefully, and strike down this statute, because I think it often deprives people of a fundamental liberty with almost no due process.
Yeah, and a little bit, I mean, it's even if there is a hearing, and there's rarely, yeah, correct me if I'm wrong, sometimes there's a hearing before the order is granted, sometimes not. Even if there is a hearing, these things are granted on such a heavy percentage that the accusation is as good as the conviction.
Yes, yeah, they are. Judges tend to err on the side of caution and enter these restraining orders just to sort of cover their tail, so to speak. So that they are issued with very little, sometimes almost no evidence supporting any finding of dangerousness or violence toward anyone else.
I hope this goes away. When it became law, it was known as the Lautenberg Amendment. Lautenberg being the former senator, now late senator from New Jersey. One
thing that's interesting too is that this type of course, we know from Bruin, and let me back up a little bit. We know from Bruin that if a law burdens the right to keep and bear arms, that law has to be supported by the text, history, or tradition, and you show that support through analogy primarily. And the analogies that they came up with here just really weren't sufficient analogies. The primary one and the closest one was what were called surety laws, and the difference, the key difference between surety laws and these and the way these restraining orders apply, is that surety laws did not deprive the person of a weapon, either the ability to carry the firearm or the ability to possess it. It simply required that they post some amount of money to offered as a surety to basically incentivize them to behave, so to speak. So that's not the same as these civil restraining orders, where you actually lose the right entirely as long as you're subject to this restraining order. So the closest analogy they had wasn't really close at all. And so I don't think that, and that's what the Fifth Circuit recognized, was that they could not support this restriction, this prohibition on the possession of firearms by the text, history, and tradition of the Second Amendment.
Yeah, and so what we really need to do, there are two things we need to do. Number one, we need to pray for the health of the conservative justice, or the originalist justices on the Supreme Court, and we need to work like heck to make sure there's somebody in the Oval Office in 2 years that will put originalist judges back on the Supreme Court when eventually the ones we have retire. So.
Yeah, well, and we know too that's really seems like a strategy of the anti-gunners right now, is to try to prolong litigation as long as they can, with the hope of the composition of the Supreme Court changing at some point. And we certainly don't want that to happen. So it's important, like you say, to stay engaged and to make sure that the next person that's in the White House is somebody who will appoint judges that are faithful to the Constitution and faithful to our individual rights and liberties.
Yeah. One of my, and this is going a little bit left field here, one of my most detested phrases is the Constitution is a living, breathing document. No, it's not. It's written the way it's written. It says what it says. It can be changed, but it's not a living, breathing document. You do not get to interpret it whatever way you feel.
Yeah, that's exactly right. I think that theory of constitutional interpretation is extremely flawed. I mean, think about it. If you went to, first of all, it's important to understand that the Constitution was a contract between the states. And if you sign a contract with somebody and they just say, oh, I can interpret it how I want because it's a living, breathing document, nobody would think that that's appropriate, right? If I sign a mortgage with the bank and they say we can change it whenever we want because it's a living, breathing document, nobody would be okay with that.
No.
And that's the same thing with the Constitution. There's a specific procedure that's been prescribed to amend it, to change it, and those procedures have to be followed to do it. And it's not something that you can just change on the whims of a judge who decides that they want to change it.
We get a comment in here real fast. I just want to make sure I've got it going to the right place before I do that. And I do. Okay, here we go. C&T Designs and Arms. Coop says, we need law professors that will train the next generation of constitutional judges. If not, we're done in 10 years max. Alex, that's why it's so important, my opinion, that we get people that will appoint originalist judges. Say what you will, think what you will about former President Trump. The best thing, and he wasn't a pro-gun president, the best thing he did give us was 2 justices on the Supreme Court that solidly land on the side of individual freedoms and gun rights.
Yeah, and to the comment too, I don't know why this is. I've had this conversation with other folks. I don't know why, but the legal profession tends to attract people who are anti-gun, who are more liberal in their worldview and orientation. And he's right that, I mean, we need more judges and law schools who are faithful to the original text and meaning of the Constitution, because without it, it means nothing at all, and it does nothing to protect our individual rights and liberties. So I don't know how to change that from a sort of a methodological standpoint, but he's certainly right. We need more lawyers, we need more judges, we need more law schools to promote the individual liberty perspective when it comes to interpreting the Constitution.
I'm going to go ahead and move on to our next story here. This with the story about the Seventh Circuit. Attorneys for gun rights supporters seeking to overturn Illinois' sweeping gun ban Attorneys for gun rights supporters seeking to overturn Illinois' sweeping gun ban faced tough questioning Thursday from a pair of federal appellate judges in Chicago. The half-dozen challenges being heard in a consolidated case before a 3-judge panel of the 7th U.S. Circuit all hinge on whether the individual right to bear arms under the Second Amendment extends to more than 100 types of guns that are subject to the state ban, including the popular AR-15 rifle, and to the high-capacity magazines that are also subject to the ban. For those challenging the law, the answer is simple, particularly in light of a U.S. Supreme Court ruling last year that struck down New York State's concealed carry law and established that restrictions on firearms ownership must be consistent with the country's historical traditions of regulation. I've got a couple quotes here. Millions of law-abiding Americans possess the semi-automatic rifles, pistols, and shotguns that Illinois has newly banned, and millions more own the magazines that Illinois has now declared illegal, said Aaron Murphy, an attorney for the National Shooting Sports Foundation. The Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin forecloses the state's effort to prohibit them because the case teaches that our historical tradition is one of protecting arms that are in common use today, Murphy said. Again, going back to history, when Lexington and Concord, which touched off the Revolutionary War, when that battle came across, the British were coming for our cannons and the powder that was used in those cannons. They weren't coming for muskets per se. They were coming for the cannon and the gunpowder that went in the cannon. So we had weapons of war at that time.
Yeah, we certainly did, and I think that the common use test that we learned about from Heller, that was developed in Heller, really sort of recognizes that the arms in common use at the time are the arms that are protected. Well, let me back up. The arms that are in common use for lawful purposes, including self-defense, but not just self-defense, are arms that are protected by the Second Amendment. And that would include arms, obviously, like the AR-15, because we know from Caetano that where the court found that stun guns were in common use, where there were only a few 100,000 in existence, there are several million AR-15s in existence for common use for lawful purposes. So the AR-15 would certainly be an arm that is protected by the Second Amendment. And unfortunately, I think we're likely to lose this case in the Seventh Circuit because Judge Easterbrook, although he was appointed by Ronald Reagan, is no friend of the Second Amendment. And there are two other judges on this panel in the Seventh Circuit. I don't know about the third, but at least one other is also not friendly to the Second Amendment. So we're likely to lose this one, at least in the Seventh Circuit, in my opinion. But I think ultimately we will prevail with respect to these challenges banning the AR-15.
So should we lose it? And I agree with you. I think we probably will lose at the three-judge panel. Do you think it will go en banc? Do you think they'll go to the full Seventh Circuit and ask for an en banc appeal, or do you think they'll jump straight over that and go to the Supreme Court and ask for cert?
I would think that it would skip the en banc process. That's just a guess. I don't know that with any degree of certainty, but I believe that it would go to the Supreme Court likely at some point, because I think this is an issue where there's going to be a circuit split. If there's a Seventh Circuit, if the Seventh Circuit here says that the ban is constitutional, I think we're going to have another circuit, whether it's the Fifth or some other, that says it is not constitutional, and we have a circuit split. So that would be a case ripe for review by the Supreme Court.
Well, and we're still waiting for the assault weapons ban in California be ruled on by St. Benitez. I got to think that that one's going to come down on our side, and this could create that circuit split because the Ninth set that back down to him for him to decide.
Mm-hmm.
And so is it when he decides now, would it have to go back up to the Ninth, or is this?
It would have to go back to the Ninth, yeah. So it would. I don't think there's much of a chance that the Ninth would say that the AR-15 ban is unconstitutional. So the split would need to come from somewhere else, more than likely.
Okay. All right, and that's unfortunate because the Ninth, and I don't know if I still. One time you and I had a map, and I believe I still have it in here somewhere. I do. I'm going to put this map up so I can make my point here. The unfortunate part is the Ninth Circuit is California, Oregon, and Washington, three states that are working hard on. And Washington has an assault weapons ban. California has one. Oregon has been fighting to get it through, and I think they finally. But
and let's face it, too. I mean, the Supreme Court seems eager to resolve some of these issues. I mean, they took up the Rahimi case, and I think especially with the AR-15 bans, they're going to be eager to resolve those issues in light of Bruin, not only to resolve that issue because it's of particular public importance, public interest, but also because they want to give more guidance to the lower courts about how they should be utilizing the test established in Bruin.
Well, and let's, again, we're staying in federal courts. This time we're going to move to the Fifth Circuit for this one. In a win for gun rights advocates, federal judge declares ban on felons possessing arms unconstitutional. And here's another guy that is not exactly a poster child for gun rights. Jesse Bullock argued that his 1992 felony conviction for aggravated assault and manslaughter and his 2015 conviction for attempted assault of a law enforcement officer should not bar him from exercising his constitutional right to own firearms. In the latest application of the Supreme Court's Second Amendment jurisprudence, a federal judge from the Southern District of Mississippi, Carlton Reeves, has overturned a man's conviction for gun possession, declaring the federal ban on felons owning weapons does not pass constitutional muster under the Second Amendment. I'm just going to, on this, look, bad guys are going to be bad guys. That's why we need to convict them of real crimes like manslaughter, like aggravated assault, like assault on a police officer, and leave the gun crimes alone.
Well, and I tend to agree with you. You said it on the show before, and I tend to agree with you that if somebody is really dangerous, they should probably be in jail.
Oh, yeah.
Right? And it's interesting, this opinion, the judge spends quite a bit of time complaining about the test established in Bruin and the Bruin opinion, but then but sort of begrudgingly applies the Bruin test and comes down with this headline-making decision. So it's interesting that he was sort of very reluctant to follow the Bruin and wanted to let that be known, the Bruin test, but wanted to let that be known, and nevertheless, I think, applied the Bruin test appropriately in coming to the decision.
If we could only get this guy to move to Chicago and get on the Seventh Circuit Court of Appeals. Admittedly, he's not on our side, but at least he follows directions.
Right. Yeah. Because these are, let's face it, this is a U.S. District Court judge. The judges in the Seventh Circuit are circuit court judges, but they're all inferior courts. And I think Judge Easterbrook, particularly in the Seventh Circuit, and Mark Smith from the Four Boxes Diner is who pointed this out, I think feels a little jaded by the fact that he was never selected to be on the Supreme Court, because he's probably one of the most, if not the most, prolific circuit court judge in terms of his writing and his thinking. He's very smart, very intelligent, but not pro-gun, not pro-liberty in that respect. So I think some of his writing, I think, reflects that feeling of being left out. And you can see that come across in the oral argument and also in some of his opinions about the Second Amendment.
Speaking of Easterbrook, we just got a comment in from Roderick. He says, FYI, strange as this might be, but Judge Easterbrook is an originalist, many times speaker at the Federalist Society functions like the majority on the Supreme Court that did Bruin. He had strange questions, including about the Winchester rifle.
Yeah,
and I got to admit, I haven't even read the transcripts yet. So,
yeah, Judge Easterbrook, he's like I said, an incredibly intelligent person, great writer, but for whatever reason, I don't know if it's because being in the Seventh Circuit around Chicago, I'm not sure. I've never fully understood his approach to the Second Amendment.
All right, next story I want to get in here. This one out of Hawaii. I got this off abcnews.com. Suns out, guns out? Not on Hawaii's world-famous beaches. Beginning Saturday, a new law prohibits carrying a firearm on the sand and in other places, including banks, bars, restaurants that serve alcohol. 3 Maui residents are suing to block the measure, arguing that Hawaii, which has long had some of the strictest gun laws in the nation and some of the lowest rates of gun violence, is going too far with its wide-ranging ban. Residents carrying guns in public is new to Hawaii before the Bruin decision. I want to get down to a quote from the attorney that filed for these 3 plaintiffs. And you're gonna, if you followed the show, you're gonna recognize the name of this attorney. Alan Beck, an attorney for the plaintiffs, said his clients especially want to protect themselves at isolated beaches where they might be fishing or going on a walk rather than sunbathing or swimming. The truth is, it's probably safer at Waikiki Beach during the day when there's, thousands of people around, he said of Honolulu's tourist mecca. But a lot of these beaches in Hawaii aren't the beaches people think of when they see movies or TV. Alan Beck has done a lot of work for the Second Amendment Foundation. He's one of the rock star attorneys we work with, although I'm not certain, I do not know if this is an SAF case or not. But it's unfortunate. Hawaii is a part of the Ninth Circuit, so.
Yeah, and we've seen a lot of examples like this where in the wake of Bruin, these anti-gun jurisdictions are anxious to try to ban every place that the sun touches from being able to possess and carry a firearm. Their definition of a sensitive place is just about everywhere. And I don't think that complies with the test in Bruin or the Constitution in the least.
All right, one last story I want to get to today, and I found this just minutes before we went to air. This is off No Lawyers, Only Guns and Money, John Richardson's blog. The NRA sought to intervene in the Second Amendment Foundation's case entitled Rainier Arms versus BATFE, the case challenging the Biden pistol brace ban. As with Mott v. Garland, the plaintiffs, including all members of the Second Amendment Foundation, were covered by the injunction against the enforcement of the pistol brace ban, while the Fifth Circuit Court of Appeals is taking up the case. When the NRA sought to intervene, the Second Amendment Foundation did not oppose this motion, but it was opposed by the Bureau of Alcohol, Tobacco, Firearms, and Explosives. Basically, what it comes down to is a judge today has said that, no, NRA, you just weren't timely enough. We're not going to allow you to join this. And there came out a press release late this afternoon from SAF saying, well, if you want to be covered, NRA members, if you'd like to be covered, come join the Second Amendment Foundation. You still can be.
Yeah, and I think, under federal rule, parties are allowed to intervene in a case under certain circumstances. In some circumstances, it's an intervention of right. It means they have a right to intervene without the court's discretion. Another is permissive intervention, and the NRA here would have been intervening under the permissive intervention portion of the rule, which means the court had the discretion not to allow the intervention. And here, the court obviously ruled against the NRA, primarily because of timing. They were simply too late to the party. And the SAF, I think, smartly invited NRA members to join the party as an SAF member.
Yeah. And $15 for a one-year membership, $150 for a lifetime membership. If you want to be covered under that Fifth Circuit injunction, go to saf.org/join. And while you're there, all these lawsuits that we have everywhere, they're not cheap. So if you'd kick in an extra $50, I'd be grateful. And I know everybody else at the SAF would thank you as well. Alex, we're down at the bottom of the hour. Before we take off, though, man, please tell everybody about the Forge of Freedom podcast.
Yeah, so the Forge of Freedom podcast is a podcast I started at the beginning of the year. As all of you know, I'm an attorney and a firearms instructor, but my passion doesn't end with firearms and the right to keep and bear arms. I care about freedom more broadly and talk about a broad range of topics on the podcast. In fact, this weekend, I'm going to be talking about a class I recently took with Greg Ellifritz. It's somewhat related to firearms, I suppose, but it was a tactical first aid and system collapse medicine class that I took last weekend with my wife, who's a physician assistant, so she'll have some expertise to bring to the podcast on this topic as well. So we're going to talk about that. Every Monday we release a more gun-specific episode, and I normally have my father, Mike Ooley, on the podcast for that Monday Gun Day episode. So if that's of interest to you, you can find the Forge of Freedom podcast on YouTube, Rumble, or just about any podcast streaming platform. So check it out. I'm also on Twitter at the Forge of Freedom.
I got to tell you, man, this has been probably a little more than a week ago. Last time I was able to sit and consume podcasts. I actually listened to one that you and your wife did together, where you went to, for the lack of a better term, it was almost like a prepping conference. I found that one fascinating, man.
Yeah, I didn't get to go. I just got to do the interview afterward. But my wife and her sister and a few of her friends went to the Homestead Festival in Columbia, Tennessee, and they learned about all kinds of food production and raising children to be resilient, and all sorts of wonderful things to try to live more freely and independently in a world that seems to be less and less free.
All right. Well, we do have to get out of here. That does wrap up the Monday through Friday version of The Bullet. Do please come join me tomorrow evening as I pull up my calendar to see who's going to be here. Tomorrow evening at 7 p.m. Central Time is going to be Alex Ooley, Dan Was, and I don't have a third person in there, but I do believe I've got that third seat filled. I just don't remember who I stuck in there, but we'll find out tomorrow. Thanks for watching today, everybody. Until next time, hang in there.